All right, everyone, welcome back to the channel. Today we are once again entering the intense and unpredictable environment of Judge Coleman's courtroom, where a familiar sovereign citizen has returned, bringing with him the same disruptive energy as before. Those who have followed his previous appearances already understand that this is never an ordinary proceeding. It is a situation that quickly escalates into confusion, argument, and tension. His refusal to acknowledge standard legal authority and his persistent attempts to challenge the court's legitimacy create an atmosphere that is both chaotic and compelling. As the session unfolds, it becomes clear that this encounter will once again test the patience of the judge and everyone present, setting the stage for yet another dramatic and disorderly courtroom exchange.
While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Jabbar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in the first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Jabbar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor.
In the previous episode, this individual was aggressively focused on threatening legal action against Judge Perkins, making bold and questionable claims in an attempt to challenge the authority of the court. However, in today's situation, the narrative shifts in a different and equally dramatic direction. Instead of targeting the judge, he has now redirected his frustration toward the police officer responsible for pulling him over, escalating the conflict to a new level. This change in focus introduces a fresh layer of tension and unpredictability as his confrontational behavior continues to unfold. With emotions running high and his determination to argue seemingly stronger than ever, the stage is set for another intense and chaotic encounter that promises to keep things anything but ordinary.
All right, I see that there is let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
Well, I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something?
Make little sense. In a way, that level of self-assurance can even be strangely fascinating to watch. What becomes truly frustrating, however, is the way they choose to present it all, recording every moment with camera quality that looks hazy and unclear, as if the lens has been covered in a thick, greasy blur. It takes away from whatever point they are trying to make, and turns the entire viewing experience into something distracting and difficult to follow. If they are so committed to documenting their perspective, the least they could do is ensure the visuals are clear enough for others to actually see what is going on without unnecessary distortion.
A jurisdiction that doesn't have jurisdiction, a 36th district court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th district court, as well as this procedure. I'm
not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yeah, yes, sir. And
Let
we
me go to
understand
the-
that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who is representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this.
At this stage, the situation becomes just as confusing for the viewer as it appears to be for Judge Coleman, because the reasoning being presented simply does not hold together in any logical way. It is difficult to understand why someone would go through the effort of filing a motion in a court system while simultaneously insisting that the very same court has no authority or jurisdiction to even consider it. This contradiction undermines the argument entirely and creates a cycle of confusion that goes nowhere. What makes it even more puzzling is that this is not a unique occurrence. Similar scenarios have played out before, where individuals have taken their cases to higher courts only to argue that those courts lack the power to hear them. It highlights a pattern of inconsistent thinking that turns legal proceedings into something far more chaotic than they should ever be.
Where the defendant is in default in this matter, he's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, fail to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that the defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. I started off Brian Ambrosius stopping me.
In simpler terms, The request for a default judgment does not hold up and should be rejected, primarily because the defendants have already provided a response to the motion, removing any basis for such a claim. Furthermore, the allegations directed at the officer lack a solid legal foundation, as the complaint fails to establish a credible or persuasive argument that would justify proceeding. The overall nature of the case suggests that it may have been filed out of retaliation rather than genuine legal grievance, making it appear frivolous from the very beginning. Adding to this, the officer is shielded by governmental immunity, a legal protection that prevents such claims from moving forward under these circumstances, and this is a principle the judge is fully aware of, making the likely outcome even more predictable.
And the default judgment, what are you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's action being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michaels, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birth.
At this point, it feels like a perfect storm of bad judgment, misplaced confidence, and the internet's ability to amplify the most confusing ideas has somehow led us right here. What we are watching does not come across as a carefully thought-out argument, but rather as a chaotic mix of misunderstandings presented with absolute certainty. The situation seems less like a serious attempt to make a valid point, and more like an example of how easily things can spiral when flawed logic is combined with a platform to broadcast it. Instead of clarity, it creates a moment that is both baffling and strangely fascinating, leaving everyone trying to figure out how it reached this level of confusion in the first place.
You failed to state of action upon which the court could grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter. Again, the complaint is dismissed without prejudice. That would be a final order regarding this particular.
At this point, the argument begins to unravel under its own contradictions, because if someone is actively disputing their own birthright while simultaneously rejecting the recognized right to travel, they are effectively removing the very legal foundations they might otherwise rely on. These positions do not reinforce each other. Instead, they cancel out any coherent framework that could support a valid claim. By denying these established principles, the argument loses its footing entirely and leaves no solid ground to stand on. In the end, this combination of claims does not strengthen the case, but rather simplifies the outcome, leading to a clear and inevitable conclusion that there is no viable legal basis left to pursue.